interrupted.
I told Pastor earlier that I was a little disappointed that I didn't park in his spot. His parking spot. I know, I saw Julia's sign, I thought it's a long way for me to go. So, yeah, so we'll just kinda go through stuff to, get set ahead of, obviously at some point we'll all pass, whenever that might be, but to get some of your stuff in place, before that. And, I know most of you know Tim, he's gonna be our legal man to, go through all the legal stuff, so I'll go through a lot of the details and info, and we can kinda let him interject in spots wherever there is, so if you have questions on any of that, just, let us know or whatever, and you guys can chime in anywhere as we go.
Fred, can I make a comment before you even start?
Yeah,
My mother's older sister, her children are all deceased. So she asked me and another lady if we would go, well, she lived in Gillette, so we'd go to Keels and help her set up her stuff, which we did one day. I was in crutches, because I had just had foot surgery, I remember that. And, we got everything done, and then she did, she picked out her own casket and everything. We got that all done, and, well, she ended up passing in 92. And, we were at the funeral home for her wake, and one of her sisters came up to me and she said, "Who picked out Esther's casket?" I said, "She did." I said, "I'm so glad that she picked out her own casket, that none of the relatives came back to me. Why did you get her such a good one? Or couldn't you have gotten her better?"
yeah, picked it for herself.
Mm-hmm.
Yeah,
I mean, I went through this.
Yeah, and that's a good point. We do hear that on occasion. The kids come in and either wanna, buy something extremely expensive or something extremely inexpensive, and it's their call. It's no problem, but that kinda took the guesswork out of that.
Yeah, who took the guesswork off my under?
Yeah, exactly. So those forms that we gave you, they're kind of been out. I know a bunch of you grabbed some of them and some different copies. But Julia has that binder that's got the clear pages on it. She has that printed for you guys, and it has all kinds of blanks where you can fill in family members and different assets you have and different wishes you have, and it's all kinds of blanks that you can fill out and just kind of keep it on file. And so as long as you all got one of those to look through, you'll find a lot of good.
Tony, grab two.
Yeah, so that you can use that to fill out and put a lot of your stuff so it all ends up together.
Okay.
So then another form that's back there is the power of attorney forms. Some of them are for healthcare, some of them are for finances, and all the different forms. Do you want to? I know you're went through a little bit more, and then let Jim interject as needed in there.
Sure, so just some notes on those. There's the general durable power of attorney. Doesn't cover medical or healthcare decisions. Can cover a variety of things, including property, financials, business interests, insurance, the estate. You can appoint someone to cover all of those things, be a broad sweeping document, or you can pick and choose various things from that document to have the person appointed to do.
So that you said that doesn't cover medical, or it can cover?
No, it never covers medical or healthcare, but it does cover a variety of things in that document, like the property. There's a whole list.
Okay.
And you can appoint all of those things to one person, or if you have one child, you wanted to do a couple of those things. I think there's the directions to initial certain things. Otherwise, you can go to the very bottom of the list where you can initial to have all of them done.
Okay.
Then there's separately the basic power of attorney for finances and property. that only handles finances and property and the things listed in that document. It's a little bit, covers a little bit different things than the general durable. It's all kind of broken down better on there. There's also the medical or the health POA, which only covers medical and healthcare decisions. It covers a couple things, like you can state your wishes in there for nursing home stays, if you'd ever want like a feeding tube. And there's like an open section where you can write down some other wishes as well. Then there's also the living will, which covers if you'd ever want any life-saving measures, you want to be on life support, any kinds of heroic measures like that. Kind of a good supplement to the healthcare POA is the living will.
Yeah, definitely. Everybody hear me all right? I move around too much if I'm standing, so I like to sit. So with the living will, think of that as your guide to how you want to be treated when it is end of lifetime. That is your instruction manual. Whether you want certain things done, withheld, not done. It's important to have that, even though you may talk with your family, you may empower somebody to make those decisions. Where I normally see a dispute is where one child is empowered through the power of attorney for healthcare, and they're gonna make that decision because family members talk to them, mom or dad, sibling, whatever it might be. Other family members come and say, no, that's not what they want. So now, not only do they have the support through the living will of what you wanted, they've got a recollection, maybe their memory's not so good, maybe it's stressful time. But now if anybody questions them, they've also got that written documentation to say, this is mom, dad's, whoever's wishes, I'm gonna follow them. May not always agree with them, but I'm gonna honor what they wanted. This is their directive. So that's why it's important to have that in place. With the healthcare power of attorney, you will sometimes see if you fill one out at a hospital, that it'll have the living will or advanced directives, declaration of physicians, it's got different names, included in the same document. Not a problem, it's still valid. I caution people on doing the combination document because you may change your mind on certain aspects of what you want. And if it's a combination document, you have to change the whole document. And then you gotta get them out. Normally, hospitals, medical providers only wanna see the power of attorney for healthcare until it is end of lifetime. They don't wanna know ahead of time. You know, they want to protect, promote life. They don't wanna worry about having an old document in their file that maybe you changed your mind, but you forgot to get them a new one. They're gonna go off, it's valid until they've shown it's been revoked or changed. So I try to caution people on doing that combination document. The one document you don't have included here I like to talk about is called a HIPAA release and authorization. So HIPAA, everybody, Health Information Portability Accountability Act, basically a big permission slip of medical providers can talk to. You go to your medical provider, your family physician, they normally have one on record, have you updated every 6 months, a year. Normally, those are only for that medical provider. So if you sign it for Bellin, it's only good for the Bellin system. It doesn't transmit to Prevea or to somewhere else. You can do one that's a pre-authorization where you're saying, hey, I'm pre-authorizing these people I trust, people I want to know. Normally when I do one, it matches up with whoever you list on the healthcare power of attorney. Those people are going to make decisions. It's good for them to be able to ask questions. It doesn't replace the one they ask you to sign at the hospital or your medical provider because they're very protective of their own forms. But say you go on vacation, say you travel a lot. You might go somewhere and have a medical event and not have signed something with that medical provider. And when you're there, you might not be able to sign one. So they're going to be very tight-lipped, whether it's a spouse, a sibling, a child, a really good friend. They are told they cannot discuss things unless they are pre-authorized. So having a HIPAA that is general in coverage is good. I normally tell people, keep a copy in your glove compartment if something happens. A couple are traveling together, decide to go to Colorado, or go out to see the Grand Canyon. Something happens to one, the other one can show that pre-authorization saying, you can talk to me. I know they're unconscious. They haven't been declared incapacitated, so my healthcare power of attorney hasn't activated yet, but you can share with me because I am on that list.
And where do we get that?
I don't know I don't believe the state has a pre-formatted form for that, but I do that. I know there are other attorneys who do prepare that.
No, well, that's great info.
Yeah. So think of it in a 3-stage in the healthcare part. Sorry, I don't mean to.
Oh, you're good. That's what you're here for.
Think of it in the 3-stage part with the healthcare. The HIPAA is valid right away, and it empowers those people to be able to get information, get status. They don't get any decision-making, authority, rights, or powers. They are just free to ask questions. Even if something as simple as they call up and the nurse's station says, I'm sorry, Marty's sleeping, we don't want to wake him. Great, I'm on his HIPAA authorization, you can talk to me. That easy. Healthcare power of attorney, you sign that now. That doesn't activate, however, until 2 medical professionals have declared you incapacitated. So basically, it's signed now, but it's a sleeping power that springs to life only after that declaration of incapacity has been signed. So the HIPAA is good from now forward. Healthcare signed now, but only active after you're incapacitated. And then the living will, declaration of physicians, is your final wishes when it comes down to good Lord's got his hand on your shoulder saying you're coming home, it's terminal, it's end times. What do you or do you not want?
That form is available online.
The HIPAA form is? Is it the one you're looking at, is it Wisconsin specific or?
No, it is, it says HIPAA release and authorization. Trying to see right.
But Jim, isn't that specific to the person, the provider?
The one you sign with the provider is.
But you can't just take a blank HIPAA form, have it signed and bring it to any provider, right?
I prepare one that's been valid. I have not had any problems in any state.
Good to know.
I believe this is from HHS,
Yep, so that would only be good for HSHS.
Health and Human Services.
Oh, I'm sorry.
HHS.
HHS, okay. Wisconsin HHS? The only reason I ask that is every state has different qualifications, determinations. So, like the financial power of attorney needs to be notarized. Other states may only need you to witness it, or they may need witnesses and a notary. As long as it's signed valid in the state that you sign it in, it's valid throughout the United States. But if you sign it incorrectly, they need witnesses and you have it notarized, it's not valid. One doesn't replace the other.
So even for our adult children, they should have these 3 things too?
Yes.
Are these forms only valid in hard copy? I mean, can you have copies of them on your phone, like in a PDF format?
Yep.
So you can just say, okay, here it is, instead of having to,
So all the forms that we prepare have a statement in there that says duplicates, whether it's electronic, paper, facsimile, are just as good as an original. Because most of the time now, they're asking for you to send them digitally anyway, or they're scanning theirs. Yes, there are, going to the financial side, there are some smaller banks, sorry, Andy, that used to say, you have to bring in the original, we want to make sure it hasn't been changed, modified, something done to it, and we want the original, and we'll make our own copy of it. We've gotten away from that, but it's still good to have that, because if you go out of state, they may say, no, we need to see the original first to be able to do anything.
okay. So it may or may not be valid in another state.
Correct.
An electronic
But as long as it says a duplicate is just as good as an original, and that's valid here, it should be valid in every other state.
Okay.
This is US Department of Health and Human Services.
Okay. Yeah, so I can't speak to the validity of it without having researched and seen it. But again, if it's available online, that's where I always caution people about doing a will online, even though it says it's state specific. you could get into a problem where it's not valid.
So just the one other form we have out is the authorization for final disposition. So final disposition is what the state calls if you're gonna be buried in a casket in a cemetery, if you're gonna be cremated, if your body's gonna be donated to science. That's what the state means when they refer to final disposition. That form, when filled out properly, allows you to supersede a immediate family member, like an estranged child that you haven't talked to in 30 years, and you don't want them to be involved with your funeral planning. You fill out that form, you have it filled out properly, it's witnessed and notarized, I believe, for that one.
No, one or the other.
One or the other,
One or the
okay?
other.
I know there's the blanks on it. Yeah, so as long as you have it filled out properly, it allows us to bury you or cremate you without contacting your child.
Yep, and I've got a little sheet here I'll hand out, pass around, written by Shanna. I work a lot with this firm. It's well written. Basically, it gives the breakdown of who gets to make the decisions. If you're married, your spouse gets that priority. You may not want your spouse having that priority. A few there for you. Then it goes down to your children. Now,
That one?
Now, if you have multiple children, it has to be by majority. And if they don't agree, they're gonna say, get the will and the probate, get a PR appointed, and the judge will appoint somebody for making the decisions.
It's a
So-
long process
It
that,
is.
you
So,
know,
basically, it goes from spouse, children, parents, siblings, next of kin, legal guardian. So there is a step-by-step process. Yes, I have seen this before, where families have a dispute. Whether it's over who is making the arrangements, where the arrangements are being made, what type of arrangements, what's being spent, to somebody who just wants to be a thorn in everybody else's side, because they know they can. Husband and wife, it's pretty easy. Now it drops down, you got spouse dies, you got one parent left, you got children, they may get along. They may talk, they may go through things, yep, let's make a decision or appoint somebody to make that decision. Now, if we do a will for somebody who's never been married, never had children. They may have good family relationship with their siblings, or their parents may still be alive. They may or may not want them making decisions. They may have a special friend in their life who they never got married to, but they're the ones they want in control. This is the document that enables them to do that.
When you talk about children, children take precedence over stepchildren.
Yes, stepchildren are not in the line.
They're not.
No, because they're not of your blood. So think of it only of blood, so natural or adopted, because adopted become of blood once you adopt them.
Okay.
This also takes a lot of stress off the family. I know later you're gonna be talking about prepayment, pre-arrangement, those are beautiful things to do for family members. Number one thing that comes to me when someone passes away, how do we pay him? How do we make sure things are taken care of? Everything's been frozen. We can't access, we can't get money. But this also falls in because now one person gets to sort of shoulder the burden, who you elect. And if anybody else has a problem, they don't get a voice in the decision.
and we've been told by our association that as long as you fill out every blank and don't leave a blank in there that is not filled out, even if it's redundant or as obvious it can be, the most important thing to make it so that it can't be challenged is to fill out every blank in there and explain all your wishes. And if you leave a lot of it vague and don't list the second and third or first and second successor and all that they've been challenged before. So, you know, if you're gonna do that, just fill it out right and get it set, and, you know, maybe do it yourself or get some legal help, whatever is necessary. I mean, just so you get it so it kind of goes the way you want it to, if that day ever comes, you know?
Yep, and that form is basically name, address, phone number for the people that you want in the order that you want. Their signatures do not need to be notarized or witnessed. That is only your signature that gets notarized or witnessed. And then if you look at page 4, there's a breakdown of things that you can request. I don't fill these out per se at my office because I've had people just say, I want to be cremated by ashes shot up in fireworks. And I've had people who have a 5-page list of songs and flowers and, so it's personalized so much for everybody. It's very difficult to be able to spend that time. But a lot of times people will bring it back and say, hey, I need you to witness this. Will you look through it? We'll talk about it. Who should have copies of this? Of course, whoever you choose for your funeral director and whoever you name on here. Basically, that's about it. You can share with your other family members that you've already anointed this person or these people, but other people don't need a copy of it. Why it's important for if you go here, he knows who he's talking to already, knows they're empowered, and the people can then act on it. Again, understand though, this doesn't free up bank accounts to get money to pay. This just says this person gets the right to make the decisions and handle the affairs of your body after you're passed.
Exactly, yep. Yeah, because otherwise, not to overwhelm you, but if there's children that don't get along, if there's a spouse or whatever it might be, whoever's like that list that you have, whoever's at the top of that list gets to choose whether you're to be cremated, you're to be buried, you're to have a funeral. All of your funeral directions, without this document, that is their decision to make, to change, to do as you want. Maybe they don't know what you want. So without that document, you're relying on your next immediate family member on that list to make those decisions. And let's be honest, most of them will be fine and most know what we want, but there's some that don't, and there's some that, again, just, maybe there's disagreements, there's disconnect or whatever it might be. So that's a big area where that comes from, because in Wisconsin, with cremation, we need to have everyone's signature on that form. If there's 3 kids, we won't cremate anyone if the 3 kids do not all agree to sign that document. If it's a burial, we can go ahead with that for the simple fact that it's not irreversible. So you can always come back and you can disinter someone and do a cremation of that person that was already buried later on. So it's not irreversible. So we're kind of at a little bit less liability in a sense on that. But when it gets to the cremation part of it, we've got to get those signatures. Otherwise, we're essentially legally at fault for not following up and getting all those approvals from everyone. So.
And a common misconception is most people think, well, they're my healthcare power of attorney, they can take care of this. That falls into that role. Your healthcare power of attorney terminates at your death. Your rights leave you when you pass, and so you have to have a secondary document to name, even if it is the same person. Now, I'm hoping Wisconsin will change this. California puts it right into their power of attorney for healthcare, that you can name that person to continue that role for the burial purposes. But Wisconsin does not have that.
Okay. Yeah. Do you want to explain to them just a bit about the difference between a will and a trust kind of thing?
Definitely.
Just family, ways to handle your assets?
Yep. So I'm going to jump back to the power of attorney for finances real quickly. We talked about that a little bit. And yeah, it makes a lot of sense to initial all the lines. Well, did you print this?
Manuel did.
Oh, there, whatever copies you had found years ago, though.
Yeah.
Okay, yeah, this is an older version, I'll just warn you.
Oh, okay.
We'll have to print the updated one.
Yeah, there's 15 categories now. So basically, when you look on pages 2 through 5, 4, there are, oh, now they got, okay, I jumped ahead. All right, yeah,
It says 15.
yep, 16. a special instructions guardian, yeah, there's an updated one. Think of this as you're appointing what I call a wingman. Wisconsin Power of Attorney by statute becomes effective as soon as you sign it, so the person you name can act right away. There is a provision in the statute that you can make it a future power, where it springs to life after a certain event or passage of time. A lot of people will say, well, I don't want this to be active until I become incapacitated. Well, we know with medical science, you may not be incapacitated, but you may not be able to handle your financial affairs. There could be a gap in time if you make it a future power. So I normally recommend having a current power.
I'm confused about that.
Go ahead.
If it's a current power of attorney, can they then make decisions for you when you don't want them to? Is that what you're saying?
You have to have some trust, but while you still have your facilities, you're in control. So the question I get asked how it gets phrased to me is, does that mean they can sell my house? Well, if you're concerned about them selling your house because you appointed them as power of attorney, you're probably appointing the wrong person. But if you're living there and you see a realtor out there pounding the sign in, well, you need to make 3 calls. One to the realtor, one to your power of attorney, whoever's acting, and then to your attorney to say, we need to get some changes made here.
Because I have heard of that happening, where the kids will insist this parent goes into a nursing home or whatever and sells their house without them authorizing it.
So the power of attorney under a financial power of attorney, so the agent under a financial power of attorney is a fiduciary. What that means is they have to act for you, for your best interest, without any self-serving interest, even if how you would act is contrary to how I feel it should be done. So basically, they need to act like you, to stand in your shoes, okay? Yes, there is always some risk, but then if that happens, you have the ability to claw it back.
Okay.
Now, without a financial power of attorney, if you become incapacitated, they have to get a guardianship. Big shift here. With a guardianship, they hand your assets to the guardian and say, do what you think is right, regardless of what they would do with it themselves. So that's why having a financial power of attorney in place, whether it's structured to start right away or structured to start in the future.
So you can state that it becomes effective when you're incapacitated?
Correct. Or in 5 years, or you can select when it becomes
So you decide that before you sign it?
Correct. That's something, when I meet with somebody that we talk about, I normally do not recommend having it be a future power, because if you're not trusting that person to do right by you, you're probably choosing the wrong person. Yes, there have been circumstances where they just needed somebody only in a worst case scenario. Normally talking husband and wife, the husband's first or the spouse is first in line. So they're gonna do it anyway, even if it is a future power, because they still have ownership interest. So it's a fine line, but my preference after talking with people is normally it's going to be have it start right away. Even if you tell the people you're just my wingman sitting on the side. But the statute is set up to start it immediately upon signing.
I'm thinking more, husband or wife, I'm not worried about, but children, so we don't know who's gonna go first, so how do you, does it say something on here like, if I appoint my husband as my power of attorney, but what if he passes away first?
Then you have alternates.
Right.
So I normally recommend 2 to 4 people, so there's always a backup.
Okay.
So now there are attorneys, and it is authorized by Wisconsin statutes, that you can do a combination where it's healthcare and financial together. I do not recommend that at all, because they both start and can end differently. Plus, when you have the documents separated, you have one for financial, one for healthcare. Even if you list the same people in the same order on both documents, if, say it's husband and wife and they both become incapacitated, that might be a lot of stress on one person to be the financial and healthcare for both of them. So now you got two separate documents, they can take off one hat. I'm no longer gonna be the financial power of attorney. You're second in line, you get to wear that hat now, I'll take care of their healthcare. So that does
So they can, whoever you appoint can say.
decline or resign.
They can decline at the time?
Yep, it's fully voluntary. You cannot, just because they're listed, you cannot force them.
Who makes the legal determination that someone's incapacitated?
So for on the medical side, that is two medical professionals. It's a doctor and a second doctor, LPN, RPN, and I can't remember if it's psychologist and psychologist, one of the two. But there's gotta be an in-person, normally it's your attending physician, and then a second one. It used to be two medical professionals and COVID hit and they got overstressed and then it went down to one. Now they bumped it to having one that is a live in-person, or at least it's supposed to be, and then the second can be a peer review or a video Zoom. And normally it's, I review the records, I talk to the stand-in doctor or the attending physician. Yep, I agree, I concur with your decision, they are incapacitated. For most people, once you have that incapacity, that will mean you're incapacitated on the financial side, but it's not a given. I've had people who are incapacitated by a doctor regarding their medical side, and the doctor says, go talk to an attorney, go talk to, and if you can sit down and vocalize to me and I can, be comfortable with you over a span of 2 or 3 appointments, yeah, you still have competency while you might not have capacity. 2 medical differentiations. Yeah, I know. I can talk and make people's heads swim. I understand that.
Can't they just bury you all back and forget it?
Legally, no.
So with the, just one last little point on the financial power of attorney and the healthcare. The ones that are done by the state are valid, they are correct, they are good, but they are prepared for emergency situations. They're prepared to cover as many people as they possibly can. I'm not trying to say you have to go get an attorney, you have to sit with an attorney to talk about it, but there are a lot more options that are just given here that are available that aren't covered by these. There's a lot of things in here that people have questions on. I've had people bring in, especially like the Declaration of Physicians, and I'll talk to them about the one they prepared and say, why did you check this? Oh, well, I didn't want that. Well, you checked it that you did. And that's not what I want, because you don't get that understanding, because sometimes it can become overwhelming, especially if you're in a hospital setting and they go, oh my gosh, you gotta go in for surgery. We need to have you sign these documents now. You're not getting legal advice. You're having your family review it, you're talking about it with them. They maybe bring in a nurse or a clergy or somebody to witness it, but nobody's telling you, well, this is what it means, this is what your decision is.
So which one will override which one? If I previously filled one out, I don't remember if I did or not, at a hospital, and I fill this one out,
Normally, it is the most recent one.
the recent one, okay.
And again, this is an older one. There should be a spot in here where it says this revokes any prior ones.
Okay.
But I do that continually with mine. I revoke everything else.
Okay.
Anyone that I've done before is gone.
Good question.
Is a durable POA better to have than the basic POA?
So the durable, what that basically means is that it starts now, but it continues even after incapacity. So if you sign it now, it's valid, and then and so starts now, but after you're incapacitated, it stays in place. So I've had people try to do it where they said, I'm gonna do a POA right now, and I'm gonna have, for finances, I'm gonna name this person, but I don't trust them enough to have them do it when I can't watch them. Well, you can't have dueling powers of attorney. You can't say, well, I'm gonna sign one and only check the first 4 boxes and put my son on it, and I'm gonna do another one and just check the bottom 4 boxes or last boxes and have my daughter do that part. You can't split it that way. And people, I guess, on the last part of it, both on the healthcare and the financial, ask about doing co-agents. two people on it at the same time, do not recommend that, because anytime, every little crack becomes the Grand Canyon. If they don't see eye to eye, medical care. You have a major medical event, you go to the hospital, you're deemed incapacitated, they go to the two people and say, you got a choice, do surgery or do medication. One says surgery, one says medication, the doctor goes, great, go get a guardianship. Now we lose that golden window because you're probably talking at least a week before someone is appointed, and normally it's only gonna be one person.
Yeah, good info.
Sorry,
No, it's good.
I tend to talk a lot.
It's good info. When their heads hit the table, oh, it's too much.
So talking about wills versus trusts.
Yeah.
Really want to back that conversation and start from basically making decisions on where your assets go after you're gone. So a lot of different ways you can handle things. Primary ones, designations, beneficiaries, payable on death. You're having a contractual obligation with the holder of that account or that money and telling them, when I'm gone and the proper paperwork's turned in, pay that money out. So I have my bank account with $10,000 in it, and I want to give that to Marty. I can list him as the beneficiary. He hands them a death certificate, the bank's paperwork, that money's paid to him, it's divested, okay? You can do that with life insurance, retirement accounts, investment accounts. Now in Wisconsin, you can do that with real estate. It's called a designation of TUD beneficiary deed. Basically, you give your property to somebody, but it doesn't become valid until you're gone and that death certificate is turned in.
I have a question on that. What do you recommend when you have property like land? You want it to go to your kids, can you gift that before, just gift it? And say, here, you can have this.
You can gift it anytime you want. Whether it's recommended is the
That's-
key part, and that's a case-by-case basis.
Okay.
Because it all depends on your financial wherewithal, it depends on your children and their stability. Maybe you have one child who has a medical ailment or disability that they're receiving governmental benefits, that could disqualify them from. You've got somebody who may have judgments or may have legal issues.
Okay, what if you have two normal kids?
Yeah, but you don't.
You have 3.
For instance.
Which one's not?
And again, I don't normally recommend that transaction without having a good, solid conversation. I'm not saying, no, I won't do it, but again, there is so much background information that I get and so much that I want to talk about, because you may say, well, I just want to get rid of it. But then we have to talk about long-term care. Are there going to be issues with clawback if you have to go into a nursing home? Is there issues with taxation and capital gains? There's a lot that goes into it. I wish I could say, yeah, I can say, yeah, you can give anything away that you want, but whether that is recommended is a whole different story.
And right now, the look back is 5 years, I think, right, for assets if you ended up in some type of healthcare nursing home or whatever that,
Or,
essentially, if you.
yep, as long as, anytime you apply for governmental aid,
Yep.
even if it is in home care, and you're asking the government to participate in paying for it, they look at any gifts that you made, any divestments, anything that you moved away. And yes, they are thorough. Their microscope is like the size of the Hubble telescope. They find everything.
Yeah, exactly, exactly.
So you got one level of where things go by having that beneficiary designation, having something where you're so that's non-probate. That doesn't go through your will, doesn't go through the court system. Another means is if you're married or you have jointly owned property. So my wife and I own a house together. On it, it says survivorship marital property. I pass away, it doesn't go through probate. There's just a form you fill out that goes into the register of deeds. Now, Marty and I own 40 acres together. I pass away, if it says survivorship property, he gets half of it, he gets my half. If it says tenants in common, that means I get to do with my half what I please. And I might give it to somebody that he doesn't like. It might go through my will if I haven't designated through that designation deed. So another means of transferring things in a non-probate sense. Then we'll go to probate. That's your will. So a will does not avoid probate. Very common misconception. I have a will. Why won't the bank take it as being solid? Most people will do at least 3 wills in their lifetime. How does the bank know the one that you gave them is the most recent one? Or that it is truly accurate? That's why it gets sent into the court, someone petitions to have it opened, and then that will is validated, and you get what's called a domiciliary letter, like to shorten that, the DOM letter. That is basically your power of attorney over the deceased person's assets. That gives you the momentum and ability to be able to handle their affairs.
Does that include even if you have these forms filled out?
Yeah, because those forms are only, financial health care only while you're alive.
Oh,
They terminate upon your death. That's where the will kicks in. So anything that you don't have designated, don't have a joint ownership, that it flows naturally to the other co-owner or owners, or other means, goes through your will. Then we got a trust. A trust is a probate alternative. It is a means of a non-judicial distribution of things that don't have a designated beneficiary. So people will do a trust for a lot of different reasons. Most of the time, people will call me and say, I want to have a trust. I'll say, great, come on in, let's have an appointment. And I would say probably 75% will say, oh, because my neighbor has a trust and I think I should have one. Or somebody talked that they had a trust and it went well and I think I should have one. It's a case-by-case scenario. I'm not a salesman of trusts. I don't promote them in that end-all be-all. They are a tool in the toolbox. Most of the times where I will use a trust is when there is a family legacy. Mom and dad start with 40 acres of land. Now they farmed it and they got 400 acres. But they know none of the kids want to farm. And it's going to be a battle. One's going to want to sell, one's going to want to keep it for investment, one's only going to want to hunt and not pay anything, and the other one's in California and just doesn't care. But the last thing mom and dad want is for it to be torn apart 2 days after they're gone. Do a trust for that. Throw the land in there, make an investment for 20 years. Let's say most of it's tillable, probably pays for itself. Land values are increasing all the time. In 20 years, if you want to sell it, great, we can do that. Other times we'll use a trust is if there is a child who has a special need. Maybe they are already on disability and they can't have funds in their pocket because it'll disqualify them. The harsh thing about being disqualified, number one, you have to spend down what you received, and number two, normally you go back to the end of the line. So there may be a long gap after you spend that money before you're qualified again. We can do a supplemental needs, now it's called instead of special needs. Do a supplemental needs trust that just basically says it's their asset, their money, their inheritance, but it's not in their pocket. We have a trustee, I like using the term manager, because that person manages those assets and can go over and above what isn't covered by the governmental aid. So normally things like, got a niece getting married down in Virginia, can't afford on the little bit of money that they get in every month to go down there, or maybe they need a companion to go with them because of mobility or health issues. That supplemental needs trust can help fund that without disqualifying them. TV breaks, they want a new one. Again, may not have the funds to be able to buy that themselves, can do certain things to help with that. Or there may just be a child who is bad with money. Unfortunately, one of the big things I'm seeing coming in right now are families having children who are susceptible to fraud. Hey, pay me $5,000 and when I get that gold out of Africa, and they get caught into it. Very educated people get caught up in those scams. It happens. And so it's a means of just protecting them from themselves. Or very young beneficiaries. Got 3 kids, everything's going well, your 3 kids, you got 8 grandchildren, one of your children predeceases you, unfortunately. But their kids are still too young to have that money in their pocket. You may wanna do a trust to protect their share. Sometimes that trust is done inside the will. We call it a testamentary trust. I like to use the term a what-if trust. What if one of my kids dies and my grandchildren are under 18? Well, we can protect that money. Especially comes up when the child who passed may be divorced. And if that money goes to the child, they're under 18, naturally it's gonna go to the ex-spouse to manage and protect it for them. You might not have great feelings for them, or may not feel that they're capable of handling that. Secondary to that is you may want to bump that age they get it from 18 to something like 23, in case they're going to go to college. Help them qualify for grants and scholarships, because that money isn't in their pocket, it's technically not theirs yet. To just have somebody though come in and say, I need a trust, and say, I don't know why, I think it's easy. I think it's, I don't want to go through the judicial process of probating my will. You normally have the same procedures, a lot of the same timeframes, maybe a little bit less cost on the end going into the court. Where trusts fall apart is trusts are only designed to disperse the assets that are already in there at the time of your death, or are already designated to go in there. I've seen a disaster of a trust that was done when the couple was very young, their children were real small, and they thought this was the best way to handle it for their children, because they were still young, in case something happened to both of them. They both traveled quite a bit. Left it sit. They inherited assets, real estate, different things, never thought to title it into the trust. Had to go through probate, and probate had to be done before we could transfer the assets into the trust, and then we had to go through the trust to hand things out. So we doubled up the work. Again, I'm not saying trusts are bad things. I would rather have a good solid conversation, because most of the time there's other means of being able to handle it without having to go through a trust. One benefit about a trust is it makes things private. Probate is a court proceeding, so it's public record. People say, well, I don't want people to know what my children are inheriting. Well, if they're inheriting real estate, they just need to look at the tax records. They're gonna know anyway. But sometimes it's, I don't want people to know that I had $10 million and my 5 kids each got $2 million, because people are gonna be pecking at their pockets in a hurry. More than likely they already know. But in either event, even if you have a trust, you still need a will. I still recommend a will. Because you may inherit things even after you're gone, that if you don't have a will, can't get pushed into the trust without a will. And then that goes through the probate process. Big key to handling a trust is making sure that you're following up every couple, 3 years, because of life changes, because of, moves. I inherited 401k or IRA. Do you want that to go into the trust? Because there could be tax obligations on that transfer. Or is that going to go out? And is the trust made to protect it from getting to somebody when they're too young or unable to handle it? So there's a lot of different dynamics that can flow through it. But again, if somebody says you need a trust and you haven't asked them why, that's the starting point.
Yeah. Well, it's all good info. You guys, questions? I know there's probably a million, but if you have anything, we're here to talk about it. If anybody has anything, they're
Jim,
welcome.
I'm seeing a lot of people come in to have their tax prep done, that they've put their houses, their property into trust. That just eliminates probate? Or is there, or
For that asset, yes.
can you direct what happens to that house after?
Yeah, so the trust functions exactly the same as the will, where you're naming a trustee instead of a personal representative, but you're still designating where things go or when they go there. So I'll back up onto a will. 5 basic points on a will. what your assets are, who they're going to, when they're getting there, how they're getting there, and who's responsible for taking care of it. So what your assets are is basically what I talked about with probate, non-probate assets. So anything that doesn't have a designation where it's goes into the will. It's not like you list out 14 knives and 10 spoons and fine china. You just basically that classification. Who it's going to, husband and wife, normally, let's just say they're 3 kids, it's gonna go to the surviving spouse first, then to the 3 kids after that, down to the grandchildren if they predecease. Pretty simple, but some people may have different ideas, may want not to include a kid, may want to name somebody else to get some money or another asset. The when and how they get it is normally, again, based upon if there's young children or grandchildren that may inherit something. You may want to make it, they're gonna get it through a testamentary trust or through some other vehicle after they turn a certain age. So you still control things. Yeah, it's hard to say because normally Wisconsin avoids manipulation from the grave of assets. But if you're pre-doing it and saying, I'm not gonna put it out there forever, it's just until they become a certain age. You know, I've done the testamentary trust where people had a lot of money and they break it into 3 different parts, 23, 27, 30. I'll give them a third right away at 23. If they waste it, at least they didn't waste a whole, it was only a third. Hopefully by 27, they're on their feet. If not, well, you know, when they get it at 30, if they're still, you know, buying new trucks and ATVs and UTVs and boats and the money's gone before the next part comes in, at least I gave them a shot.
Makes sense. Yeah. Since we talked a little bit about gathering up assets and all those different forms, we suggest find all your personal information, you know, be it bank accounts, be it all the different things that your family is gonna need if or when the day something would happen to you, and have a plan, know where it is, be able to find it. We talked at the earlier session about passwords. I mean, a lot of times there's a spouse that does all the online, be it banking or, you know, whatever it is, and can't access a lot of that stuff without passwords and, you know, all the different access points to that stuff. So just stuff to group it up somewhere, wherever it is. Let your family, kids, or spouse, or whoever know where it all is, so anybody that needs to can kind of look through and get it put together when there's questions on that.
Yep, so you brought up a really good point. The newer form of the financial has a box or a line for initialing for digital property. People ask me, what is digital property? Pictures on your phone, things in your email account, recipes on Pinterest, anything that is non-physical, that's in a cloud or in a database or in storage. Without that, while you're alive, your agent can't access it. They can't ask for, you know, things that may be, so if you have pictures stored on the cloud, they can't access those, even unless they have your password and go in as you. When we have somebody want to come in and talk about a loved one who has become incapacitated, normally the first thing they ask or say is, I have no clue where their bank accounts are at, how many banks they're at, who does their taxes, what credit cards they have. They're jumping in and they have no idea how deep the water is. Having a baseline form, having some sort of spreadsheet documentation on things. However, the key is banks sell all the time. Hopefully you guys never do. But, you know, so how many times, what was Gillette? First Interstate or something, and then Norwest, and then Gillette State Bank, yes, thank you. If you do that worksheet, or you have a spreadsheet or something, if your bank changes, Or if you cancel a life insurance policy, when you update your form, don't remove that, cross it out and put, new bank, transferred to this bank. We've got, so in the probate world, people come in, we sit down, you know, the last parent has passed away. A lot of times, parents aren't very open and forthcoming of their assets and their things. And we're 3-4 months in the probate, and all of a sudden they go, we just went through a book and a stock certificate for Gillette State Bank Fellow. Is it still good? Oh, there was a life insurance policy that their parents bought them in 1920. Is that still valid? Is that still something that is out there? Or I found this bank statement, I know it's 10 years old, but they had $50,000 in the account, and that bank doesn't exist anymore. At least if there is that transactional history, that reference that, oh yeah, see that went into this account that's now $40,000. It helps smooth things out a little bit. Having an access point for passwords, codes, things like that. Even something so simple as, these are the important people that I want you to talk to when I'm gone. These are, you know, maybe it was somebody who was in the military and people that they were close to that maybe they didn't talk about. Or someone special they want honored, or just at least informed. I've had people come in that after they passed, the children didn't know that they had other children. So there is a lot of things, and again, everybody's private. You don't have to put down, you know, the full account number and your password to get into the account, but at least a generalized information, where your doctors are, if you have health insurance, if you have supplemental insurance, what bills normally come in. You know, yeah, it was great. It used to be people had check registers, and you could flip through those and go, oh, hey, there's a recurring charge here. What is this for? It's hard to do that on online banking accounts now. You don't see as much information. It's not quite as clear as we would normally write. But it is a personal preference what you want to do. There's no right or wrong way, except to say, well, when I die, you see that box in the corner, just start digging through it.
Well,
Yeah, that's not
but
fun.
that's a good point, because at least if you have everything in that box, like car titles, insurance policies, all of your,
Yeah, everything.
it left me, sorry.
Yeah, well, birth certificates or any of that stuff, you know, just to,
Marriage certificates.
yep, all that stuff. And you don't really need it, you know, when someone comes in and, you know, if they're gonna pre-plan for a funeral, or if someone does pass, we don't necessarily need birth certificates, but there's a lot of people that don't know the spelling of their mother's maiden name or grandma's maiden, you know, whatever it is, and that's needed for the death certificate. And believe it or not, we've had people that have had their birthday wrong until they found it on the death certificate, or birth certificate, I should say. And so, yeah, there's a lot of stuff
That's
like
funny,
that.
I had, clients quite a few years ago, their children are grown and have children of their own now, but, when tax returns were required to be electronically filed, the return kept being rejected. They have twins.
Oh,
It come to find out, they're at the Social Security Administration, they had recorded their birth dates wrong. They were on different years.
oh,
So it kept being rejected because something didn't match.
right.
And it took going to the Social Security Administration to figure out
Where it was.
where the problem was.
Oh,
And
jeez.
boy, that was a nightmare, because
Takes
they thought
forever.
I did something wrong.
Yeah, sure. Yeah.
For safety deposit boxes, if we've got a safety deposit box and we have what's listed in there, but would the power of attorney be able to get through the bank access to that? Or do you need to make sure they have a key and everything else?
So when you're alive, the power of attorney is valid, the bank should let them in. Of course, now, after you're gone, the power of attorney ceases.
Yeah.
And they can't get in without a probate proceeding being started. So
that's-
that doesn't mean it has to be a full-blown probate. Many banks, and maybe Andy, you can talk on this one, will do what we call a sneak and peek, where they'll open it up so they can inventory what's in there, including to see if there's a will, but they can't remove anything, they'll just close it back up and they'll say, yes, the will's in there, no, it's not. Because most people will, that's, sort of what they do. Safety deposit boxes are becoming a little bit of a,
Pain.
not something people do much of anymore, but it is viable. I had,
Am I your beneficiary?
but
She
again,
just gets the bills.
once someone is appointed, so if there's no other assets, and it's just, hey, we got the safe deposit box, we think there's something in there, you can open up a special administration just to empower one person to get in there, inventory those assets, and then see what happens.
Well, doesn't the personal representative get the power to do that?
Yes, but if you don't have a will, or there may not be enough assets to open up a probate. So right now in Wisconsin, to do 3 levels of probate. First level is what's called formal probate. That is where there's either an issue with the will, issue with beneficiaries, can't find somebody, that happens a lot. There's gonna be litigation. Formal is basically judicially overseen. Informal probate is basically, I'm not trying to say this disparagingly, but the court rubber stamps things. They just do a cursory review because everybody's agreed, everybody signed their waivers, they've done, and things are coming in, and so they're just there to make sure the process is moving forward, timeframes are met. Then there's short form probate. Basically, if your gross assets are $50,000 or less, then you don't need to go through the full process, it's just basically transactional paperwork. I'm hoping that number from 50,000 goes up, because right now, that's basically 1, maybe 2 vehicles, and you're over $50,000 already. So if you have real estate, you're already out, for the most part, unless you have a postage stamp size piece. I mean, because of its value.
Can you explain what happens if you don't have a will? Comparative if you have a will?
So if you don't have a will, it's a race to the courthouse. So let's say you're above that $50,000 level. You have children, your spouse is already deceased. Basically, it's the first one to the courthouse gets to file paperwork. And then if somebody disagrees, they'll have a hearing and they can fight it out to determine who's gonna be the personal representative. But then from there, it's set by statute how your money goes. So if you have children, so first off, it goes to spouse. There's no spouse, it goes down to children. No children, and it goes up to parents. From parents then, it goes, if there's no parents left, it goes to siblings. And then it trickles down from there. I will give an example of that trickle down. We are currently handling one. Lady passed away, and she had a will, and it was actually a well-written will. 2 people that she named as personal representatives, one of them was already her financial power of attorney, was handling her money. They both refused to do anything. Her sister, and I think she was one of 13, her sister stepped up, and her sister's, I want to say late 80s, early 90s, stepped up and said, I know I'm not getting any of the money, but I will take care of it because my financial advisor already told me there's a fair amount of money there. Right now, we are at 67 heirs or beneficiaries, 67 people who are receiving money from this estate. And she did have a will. It was just how she worded it and how she presented it and how many children her siblings had. And so it's, but I've had them the same way where people didn't have a will. And it just basically follows that flow chart. And that's where it starts getting muddy. So somebody who is maybe middle-aged, not married, no kids, would want a will because if they passed away, it goes up to their parents. What if their parents are in a nursing home? That money's gonna go to the nursing home. They may want to do something different. So there's, there's a statutory means for it to go. It's just you don't get to select who's the representative, and if you want to vary how it's protected, because now, again, the statute doesn't provide the protection if one of your kids passes away and it goes to their kids, what happens? It probably is gonna go into their estate, and then their spouse might get it. So, a will is a good vehicle to have, even if it's just something general. And it sort of can be utilized to prevent other outside things from happening. But even if you have a trust, again, having that will, if you inherit something as a means to then later push it into the trust. So a will is a solid thing to have.
And I see a lot of tax statements or where, and a lot of them got trusts behind them now.
Sure. Yeah, you see it on the maps and
Yep.
plat books and stuff.
And you're seeing right now, at least, I guess what I'm seeing right now is where people used to have their hunting corporation or hunting LLC. Now they're just utilizing trust instead of the corporation and LLC, because then they don't have the filing with the state. They don't have to do the corporate record book. They just sort of use a different mechanism to protect it.
Well, I had this experience, my dad's youngest brother, he passed, but then, you know, his wife was there, and he was pretty well off to do. And then when we got our, seeing there was no children, we all got something, and it said, like, I got 1% of his inheritance, where another, my cousin, I talked to her, she got 2%, and, you know, so how do they ever?
Because it could be in the line of blood where she may have been a closer cousin, because it may, or just how the money broke down between families. So the more.
But now, like that one that got 2%, her one sister got 0%.
Well, that's interesting. I'd have to, have to see that, but yeah, there is a full statutory diagram on how things flow and how it's broken out.
So he just must have picked and choose first and how much you got for what. I was happy with one.
Well, yeah, better than zero, right?
Yeah.
So the other thing when you're talking about estate planning is be very conscientious of updating your beneficiaries. Unfortunately, that is probably one of the biggest holes or gaps when we do probate, is people think they've got things taken care of and they're not the order they want them to be, or there's nobody there. It used to be that we'd sit down with the life insurance person and they'd fill out the paperwork, they'd confirm it that it was correct and send it back. Now, most of the time it's online. And you think you're doing it right, but you may not submit it right, may not have the right verification or validation, and they don't tell you, hey, you sent this in but it was wrong, you need to redo it. It falls back on you. So I've seen life insurance policies that have failed. I've had to deal with a probate where there was just shy of $500,000 in a bank investment account. The bank sold twice. The wife, it was husband's property. The wife had from the first bank the signed documentation that she was the beneficiary on it. It was valid for the first sale. What didn't flow through for the second sale of that bank. And when the husband passed away, she went to collect, and they said there's no beneficiary listed. She showed them the paperwork. They said he needed to do new paperwork with us. That's not our paperwork. So we had to go through probate for it. So always just, yearly, every couple of years, just making sure, writing to the insurance company, calling them saying, send me my beneficiary list. Talking with your banker, anything like that. I even have that in my estate planning checklist of things that you should do. When I send out my letter, is, hey, have you updated it? Your spouse passed away, the spouse is still listed first. Well, I know it's gonna go to the kids second. Never had the kids on their second, because when you got the account, they were not even a figment of your imagination, or maybe they were young and you didn't want them on there. Or Second beneficiary was your mom and dad, because the kids were too young and you wanted them to have it. Well, now one of them's in a nursing home. That money's still going to them and going to the nursing home, not gonna go to the kids. So CDs, anything like that, always good to just make sure that you get a chance to look at it, and if you have to ask questions, ask questions.
Yeah, well, that's all good. All good. That was part of what I was gonna say too. You hit on the updating the beneficiaries on stuff too. So be it life insurances, be it legal documents, bank accounts, all those things. Andy, I'm sure you have where the payable on death and stuff on some of the accounts people can do, or they can be put on the account, and typically then they can make decisions or, you know, write checks or do things prior if they're on the account, or after death when they present a death certificate, the funds would be freed up that they could, you know, pay the bills, pay the heat, pay whatever that needs to be paid at the end, and things wouldn't have to go through all the probate and whatever it might be tied up with. So.
Yeah, there's always a fine line to walk there, because if you have a power of attorney for finances, you don't need to name somebody else on your bank account, because your agent already has authority to do that. I do have people who will say, well, I did that so money is free or accessible to that person after I'm gone because the power of attorney terminates. Well, unfortunately, again, I'm gonna pick on Marty, I have my bank account and I put Marty on it, I made a gift of half the value on that day to Marty, and even if he doesn't put a penny in there, he can take the whole amount out, and I have no recourse to get that back from him. However, let's say that down the road, Marty goes into a nursing home. He's named on that account, and he doesn't list that on his application if he's asking for governmental benefits. That's fraud. If he does list it, that whole amount can go to his medical care, even though every dime in it was mine.
So is that if they're co-owners?
Co-owners, yeah, not if they're your agent under a power of attorney.
But can't you have somebody listed that can write checks for
A signatory.
a signature?
I don't know how often banks do that anymore, Andy, you have?
Not
any?
often, I
Yeah.
haven't seen it for a while.
Yeah, because again, if you're asking a bank for a signatory, you want a signatory, they're gonna say, well, get the financial power of attorney, because that takes the liability off the bank if somebody does start signing checks. You name a co-owner on account and they get sued, that money's can be taken. So I very much caution, I understand the dynamic of sometimes, you know, I want money to be freed up so they can make the house payment after I'm gone, they can pay the utilities, they can pay for the funeral, there's money there, but sometimes you can pre-arrange some of that stuff so most of that financial part is
Well,
taken care of.
Rick had to open up he was able to get on disability, he had to open up a checking account. And then he put, you know, his name, then I was a joint owner of his account. And me being my age, probably, they asked for the third one. So when after Rick passed, I went to the credit union and I asked him if I had to do anything. No, you're a joint owner, you can write up, you can use, you know.
Mhm.
So now, well, we put his son on. So in case I pass today or tomorrow, get everything there is a couple dollars left in there, it goes to Ryan. You know, and the same thing with Jim, my son Jim and I, and we had to put a third person on. I don't know if it was because I was 70-something.
I don't know, they've all got their different requirements
they
on
do.
their accounts, I'm sure.
Mhm.
You know, for different banks are probably a little different what they all require, but
So,
Yeah.
You know,
interesting.
yeah.
So in that case, like in her situation, if something would have happened to her, even though she was just named on Rick's accounts,
That money's exposed.
it's still, that money is, you know, exposed to anything that could have affected you.
Yeah.
You
You
know?
know, so when I walked out, I said, you mean I can spend this money?
Yeah.
I spend some every month, cause I gotta pay the electric bill on the shed. He still pays his electric bill on the shed. Cause we have a separate meter.
Yeah, well, that's all good. But yeah, it's just, it's, again, things that really you don't commonly think of, but it's out there, you know?
Yeah.
It's-
Yeah, and that's the same thing with designating a beneficiary on like a bank account or a investment account. That money becomes theirs upon your death. They're not required to spend that on your funeral, on your final expenses. So another misconception is that, oh, I'm gonna put my wife, or use somebody else, I'm gonna put my sister on this CD that I have, and I'm gonna tell her, use that to pay for my funeral. She could take that money, put it in her pocket after I'm gone, and she's not responsible. Because it's an inheritance at that point. So sometimes if you have that issue, that's where the will can be helpful, is that I'm just gonna funnel everything in so they're not fighting over the money until my bills are paid. Had one month ago, 3 siblings, they all got an equal share of a life insurance policy. All 3, my understanding, were told that that was supposed to be used to pay the final bills. One of them walked away and said, I'm not paying a thing. Nothing else the other 2 could do except pay their share and the other sibling's share.
He attended the seminar.
Don't get any ideas. We should have been coming to these when we were younger.
Yeah.
Yeah, it's all, again, all good info. I'll touch a little bit on funeral trusts and stuff. Many of you have probably heard of the term funeral trust. You know, you can take, and what we would generally do is people would come in and they would figure out their final arrangements, whether it's maybe they want to be buried, maybe they want to be cremated or have cemetery plot, whatever they all have. We would give them a price quotation on approximately what it would cost at today's value. And then they can decide at that point if they wanted to put that full amount of money into a funeral trust or part of it or some of it or whatever. And part of the reason to do the funeral trust is if you only have X amount of dollars and you end up possibly going into nursing home healthcare, you're gonna have to spend down the money that you do have before you can get on the state assistance. If you put a funeral trust together prior to going into the healthcare while you still have your assets, that funeral trust is protected from those values that essentially the state or Medicaid would use. So those couple $1,000s you can have, if you pulled the money out for a funeral trust, the funeral would be prepaid, and after you pass, there wouldn't be an outstanding funeral bill, and you would be probably, depending on your dollar amounts, once you got down to their couple $1,000 limit, you'd be eligible for the state to pay for your health care, and you can keep the funeral policy. So that's, you know, if they don't put the money into a funeral trust and they end up in the nursing home, what ends up happening is their assets are depleted, and at the end, they're gonna ultimately have a funeral bill as well. So, I mean, there's no right, wrong way to do it, but if you do it the first way, the funeral's paid at the end, and the nursing home or healthcare still gets their payment, but at the end of the day, you don't have a funeral bill as well left over. So that's the reason a lot of people do it, and some people do it, they just don't have any kids, or just want to get it put aside and just don't want to worry about it, don't want to have the kids worry about it, or, you know, anything like that. So there's a lot of different reasons that people can do them.
Does that have to be done before you would go into the nursing home?
With your asset level,
Or
with
if-
the Medicaid part,
Or
but
if
no.
you have, if you went into the nursing home and you have the assets,
You would private pay until it's gone.
but once you were there, could you set up that trust?
Yes.
As long as
you
it's
have
done
the assets.
before you're requesting medical assistance or state assistance.
Before you can
government aid.
get onto it, definitely.
So it's better, it's easier and better to do it before you're there, because if you're already on the cusp, so you've been told you're going to a nursing home or you're in a nursing home, then you're in emergency planning. And that becomes hectic. If you can do it before those times, it's good. Used to be that life insurance wasn't counted towards your asset limit, Now it is. And what I mean by that is cash value. So people would say, well, I've got this life insurance policy for $10,000 that's gonna pay for my funeral, I'm good. Then they go in a nursing home, they have to cash in that policy for the cash value to get under the asset limit.
Or they can irrevocably assign it to the funeral.
Yep. So, but that's gotta be done ahead of time.
Yep, exactly.
Yep.
So a way to protect that insurance policy from the nursing home or healthcare would be to have an irrevocable assignment to the funeral home on that insurance policy. So you'd be able to keep your insurance policy and you'd be able to get onto the state aid because that insurance policy would no longer be benefit of, it wouldn't be an asset of yours, but yet it would still be payable to the funeral home for the larger amount, you know, be it the payout value instead of the cash out value, which is usually a lot less. So then your funeral bill would be paid at the end, and then you would still, you know, you would be able to have kept that policy. Otherwise, healthcare is gonna make you cash it in, take the cash value, and pay for your healthcare with that cash value. Again, the healthcare is paid, the funeral bill is left at the end, unpaid. So if you literally just call the insurance company and get for a form that's typically called an irrevocable assignment, and you could assign it to the funeral home, you still remain the owner, and if you want to change the funeral home name, you can at any time, but it's taken out of your name as an asset. That's the key thing with it.
I don't know if you know this or not, is there a limit on how much the life insurance policy can be to be able to do that?
Not that we found.
Okay, okay.
Have you found it?
No,
Yeah,
because, you know, it would be very odd, I have $1 million policy.
Right.
You know, he's not gonna get the $1 million, he's gonna get his bill paid, and they're gonna, so I don't know if there's a cap on that or not, would be a good question to ask if you have a high value policy.
But then the state would get their portion.
At the end, it would have to go back through a state recovery if there's extra. If
And
there is,
if there was anything left, then that would flow through the family,
Mhm.
or
no,
whoever you
not
have.
if they're on state aid, the extra before it can go to the family has to go to pay for the care that the state paid for first.
Right.
So if there was a sizable amount and the healthcare was a sizable amount, you'd kind of have to do the math on that, and if you paid it all, then you would get the extra, but typically, you know, the nursing home care, it's, you know, $6,000-8,000 a month is what I've been hearing, so it goes in a hurry, it adds up in a hurry, so,
Nursing home right now, I think locally, the trend is entry level is about 10 to 12.
is it already?
And assisted living bumped up, and I think,
About half.
yeah, 5 to 6 for if you don't need extra care.
Okay.
You know, and then any additional go on. Now, I know there's a difference between what you pay in Gillette compared to what you pay in Shawano, just because of extra services.
Yep.
So the flip side of that is that if you have money and you need to go into assisted living, if you can self-pay, you get to choose where you go. If you're looking for governmental assistance, you're probably gonna get a very short list, and it's probably gonna be by rate, by availability. May not be where you wanna go, or the best level of care.
Well, that's a good question. If you are in assisted living and you deplete all of your funds, do you get moved to where they can pay, or
My
do they let you
understanding,
stay?
what I've dealt with historically is as long as you've been there, they'll do whatever they can to keep you there because you've established yourself.
Okay.
It is where somebody is spending it down before they get there,
Yeah,
and then they're going, well, you know what, government, pay for me, I wanna be here, and they're going, no, we can put you here because it's on our dime.
And I think those assisted living places will analyze your assets before they accept or deny you, I would assume, wouldn't they? Because if you're on the verge of, you know, having all of your financial stuff gone, they get paid a completely different rate from the state than they do from the individual. So they want the private pay people if they can, because the private pay rate could be double or triple of what the state pay rate is. So they try, I mean, financially, they try to keep people that are private pay, but like you say, once they're in, they probably don't essentially, make you move out or anything, and they'll accept the state money after that.
Well, about a year and a half ago, they had that where an assisted living facility, or no, nursing home in Green Bay transitioned fully to only self-pay.
Oh,
And they had a big hubbub because they were telling people, you gotta move out in a month or two. And most places are transitioning to private pay compared to, small local nursing homes are dying because of it, because they can't get quality help. They can't get enough funding to pay. But Wisconsin right now is doing a really good job, and I'm hopeful they'll continue with it, in that they are starting with in-home care first. They want you to be in your home, and if they can provide a level of care adequate to keep you in your home, they found, number one, it's less expensive. Number two, people are happier being in their home rather than assisted living or in a nursing home. And number three, healthcare people are much happier doing in-home care. They get to spend an hour or two with you one-on-one, not in a nursing home setting where there's 48 people and everybody's an emergency pulling their cord or ringing their bell, and they can't give you that one-on-one time. But I didn't see this until it was told to me. They get to leave, get in their car, reset, and prepare for the next one. And that's why so many nurses now, especially the well-educated, long history in that occupation, have transitioned into home health care because it's much more enjoyable. And it's surprising how many of them show up at funerals, have a personal connection, even if you read obituaries. Thank you to a home health nurse, Jean or Fred or whatever it might be, because of that little bond, even if it's a couple hours a week. But I'm hopeful Wisconsin continues funding it that way, because it's really strong.
yeah, well, good. So, yep, and we talked a bit about the funeral trusts and the life insurance. So again, you don't, some people always ask, do you have to prepay for a funeral? If you come and look at it, plan it out, get things figured out, no. There's a lot of people that come by us, just write down some notes, have some ideas, maybe give us the name of their kids or just some of their general ideas that they're looking for, and we can make a file and maybe type their obituary out or whatever it might be. Do you have a question?
Yeah, so if you have a funeral trust and you put in a certain amount of money and, you don't know what the cost is gonna be.
Yep.
So is that money gonna grow like an investment so that as the cost of a funeral rises, your investment's gonna rise with it, hopefully?
Yep.
Or whatever.
How we set them up is we would put them into a typical life insurance policy. They'll grow depending on a bunch of factors, age, they have a whole calculating factor, and they'll grow, I guess I'd have to look at a chart, but they'll grow at the percentage depending on their formulas. In say you put $10,000 in a funeral trust today, that money is always yours. The interest grows with your account, stays with your account. At some point, the funeral home has to have inflation or they'd go out of business with the cost, things going up at some point. So typically the cost of your interest growth has been keeping up with the cost of the inflation. So we've had some crazy inflation the last few years. I mean, some of that's, getting to be hard to keep up with, but generally that's the whole idea. And let's say again, you put $10,000 in there. If you come in and your family picks out a $6,000 funeral for you in the future, we don't get to keep that extra. We don't get to keep the interest. We only get paid for the funeral that we provide. The extra gets refunded back to your family or your estate, or if you would be on Medicaid or like state assistance, it has to go back to the state first. But typically otherwise, that excess can get refunded back to the estate or to the family. So yeah, so just so sometimes people just assume that because it's put in, it's just paid up and the money is just ours to do what we want with it. But it's literally an investment of yours that grows at that certain rate, and then it gets applied to the funeral bill according to what's picked out. So, yeah.
So right now, what is a no No frills, basic funeral cost.
Are you talking something with like a cremation, or are you talking something more burial related, or, okay, if you do something with just a real simple, like a cremation, that's everything you need, you know, 24-hour availability, the container that would be necessarily to go to the crematory, and everything other than a permit that would be needed from the medical examiner, you're talking $32.95, so $3,295 our charge. So if you get to something with a,
I said, that's what you're.
I was gonna say, am I hearing threats over here? As long as you don't name the date of his funeral.
No, you know, we gotta account for inflation.
Yeah, right.
How much do we save if I dig my own hole?
All of it.
I'll get started on that.
Yeah, but then if you get into something with a more of a traditional burial, you know what? But you gotta purchase, the cemeteries are all around here, pretty much all other
Okay,
than,
I got that done.
well, but they're gonna require a vault. Other than Christ Lutheran and Hints is the only cemetery that doesn't really require a burial vault around here.
Well, if you put the
Yeah, I know, that's how I was,
casket inside,
yeah, I know,
if you
that's
put
how I
the
was saying
casket
it.
in the ground like that,
They'll let you there, yep.
Or Mike can build a wooden vault.
You can do
I need
anything,
one, we're from Hanson.
yeah,
it's the
so,
what?
yeah.
So all the other ones require a vault.
Yes, cemetery required, not state, not county, not us, not anyone, but it's the cemetery, because think if you put whatever in the ground, but if you bury a casket, be it metal, steel, in an individual, at some point it's gonna cave in. You know, whether it's a couple of years or 50 years, who knows, but it's gonna cave in, it's gonna settle. They're gonna be landscaping, seeding, you know, nonstop, and it doesn't sound like much doing one, but when it's a cemetery, that's kind of all of them, you know, so pretty soon that got to be such a labor-intensive thing, that's why they required the vaults. So the vaults essentially make everything, the ground more stable, and, you know, they do ultimately seal the casket, but, I mean, it's, their main thing is the settling and stuff like that. So you gotta purchase a vault other than Christ Lutheran, but if
I
you,
wanna join your church.
and then, you know, someone's gotta dig the grave, which is typically about $700 now for a casket.
Oh, casket or a grave hole?
A casket, for a full-size casket, it's about $700 now.
Dig the grave hole?
Doesn't it?
Yeah.
Holy moly.
Yep,
No, Jim
Yeah.
Winkler used to, maybe I can
He's
get a
still in
family.
charge
Yeah.
of it.
he measures them, Jim Caston digs them,
Yeah.
yeah,
Maybe I can get a family discount.
right?
Well,
But-
it used to be years ago, the neighbors went there and dug the
Yeah.
hole. I remember my dad going and digging a bunch of.
So how much is a vault then?
So a vault, you're talking $2,500 for a vault. Obviously, there's multiple, there's sealed and non-sealed vaults. Again, not to get into, but the cemetery requires something. So you're like $2,500 for something for a vault that meets their requirements, and then something for a casket. And, you know, there'd be the preparation and stuff of the body for more of a traditional service. So you're talking, you're probably right at $10,000 to do something for a traditional traditional service.
Cremated too.
Yeah,
And then you have to buy the cemetery plots.
correct. Yeah, usually those aren't super expensive, and a lot of people have them in the family,
I
but
know.
some don't, and yeah, just depending where you go, some of the, do you even know what breed is now, Ethel, for a cemetery lot? Maybe a couple $100 at the most.
100 and 500 if you're not
Okay,
a resident or taxpayer.
yeah, okay, so $100 if you're a property owner in the town of Breed, and so,
Mine was
Where are you
24.
gonna get buried?
yeah, I can remember.
Mine was 8, mine was 8, Willie.
Yeah, I can remember the AIDS, Dad showed me some of those.
I paid 8.
Yeah, oh yeah.
Okay, now, say a cremation, you got the, well, Dixon of Carter. He's in an urn, but it's like marble. Do I have to get another thing to put that marble box in?
Most cemeteries, no. Some cemeteries require an urn vault. So like you get more in the cities and the bigger cemeteries and stuff, they're gonna want an urn vault. Like the city of Gillette needs an urn vault for Wanderers Rest. There's a mountain cemetery wants a urn vault, but most of your little church cemeteries just are like, they don't require a specific urn, but they highly ask us to get something for a rigid, realistic, something realistic for ground burial, because the cemetery is liable to be able to locate those ashes, say 50 years from now. If you guys say you want to move out of state and they've got to, you know, take a rod or dig or whatever they're going to do to try to find those, they're legally liable to find and return those to you. So that's why they want them in something rigid, not a cardboard box that falls apart. I mean, I know it is ash that's in there, but that's the reason that they typically want it in something like that. It's really not for any other reason than the liability is a lot of it.
Okay, I got a naive question.
Yeah.
If you get cremated, do you have to be put in the ground?
Nope.
No,
The state of Wisconsin last,
If you don't get cremated, do you have to get put in the ground?
well, it's gotta be a legal cemetery in the state, or out of state, but it's gotta be a legal cemetery.
I mean, if
We
you do,
could shellac you and just leave you in the corner.
seriously, if you get cremated, because I know Mike wants to be cremated, I wouldn't have to bury him, right? I mean, if I wanted to
Correct, you can
keep
take them
him
home.
at home,
Dick's on his chest of drawers, Rick's on the shelf in the shop.
oh yeah?
Something to think about, since you got to that topic. Think what's gonna happen in 2 years, 20 years, 100 years,
That'll be my kids and grandkids. probably. I can do something with them.
as long as you're okay with that. That's all I just, cause we've had, the trend now is that people are bringing urns and remains into us and saying,
What do I
what
do?
do I do with these? I don't want them anymore. Like, what can I do with them? And of course, we tell them the right thing to do would probably be to go to a cemetery, but we can't tell them what to do. We give them their options, and I hate to say it, but a bunch of them have said they're going in the trash. So I mean, not what I suggest by any means, but you hear it, so just something to think about. So we kind of just bring it up and tell people, if you go to the cemetery, at least you know that that's going to be maintained forever. You know, be it the cemetery's going to maintain it perpetually. Some people it's not a big deal. Some people it's a really big deal. So as long as you're comfortable with it, knowing that, that's all I would really get into thinking about. So, yeah.
The traditional burial, you said about $10,000.
Yeah.
Does that include, like the visitation and everything?
It does.
So if you don't have a visitation, that would cut down on it?
Yeah, well, of
So,
course, the less that is done and performed, you know, it'd be all things that can be taken out of there,
Okay.
for
so-
sure.
Okay, so there's different options that you
Yeah.
can look at.
Oh, yeah, 100%. And Wisconsin regulates everything that we do. We've got a general price list that has everything that we possibly offer on it. We have a charge that's listed that we have to maintain the price list. So if you come in and sit down, we would handwrite, or, you know, whatever, type it or handwrite it, but we'd put a contract that would be just specific to what you select, and you would only need to essentially pay for, if you decided to at the time, would be the things that you wanted for the type of service that'd be required.
So
So,
that's what you would suggest, that we come in and at least.
yeah,
Okay.
yep, that's what most people do at some point, and
Do 2 for 1 deal?
And
Go ask.
you're not infringing on my space. Do
You
you
don't
have
go
cards,
to Chrysler's
do you
Lutheran.
have cards also then, so,
here,
yeah,
there should be some.
Okay.
Is there cards here, Mandolin, in that bin? I know we brought a whole bunch of stuff.
because
but-
we do need to make an appointment.
It's on your book,
Yeah, they are. It's all over on a lot of the handouts. It's on the book and
Diane?
stuff, definitely.
it's on the book.
Well, that's all I need.
Yeah. You'll find us,
Okay.
right?
Right
Yeah.
there. Yeah,
All right,
Yep.
I know where it is.
I was just thinking of walking in, no.
But when you're thinking about, since we're talking about cremation and burial and different things, something to think about that people don't always think about is, if you're cremated, oftentimes people bury 2 urns on a single lot, which makes sense if people wanna not buy 2 lots. But when you go to place a headstone, if you go to Hickory Cemetery, the lots are 3 feet wide. So you can't get a headstone for 2 people that will fit on a 3 foot wide lot. So some of them are 5 foot, depends what cemetery you go to, they're all different. Most, I'd say 4 is common. So, but it's not so much that you need that large of a headstone, but the cemetery requires that the foundation under the headstone sticks out maybe 6 inches or 8 inches or whatever, so the lawnmower can go across it and not bang into the nice part of the stone. So pretty soon you got 6 inches here and 6 inches here, and there's just not much room left on a single lot. So as long as you're okay knowing what your dimensions of your cemetery lot are and okay with that, 2-on-1 is a great idea. It's just that's something to consider that often gets overlooked, because we often hear from the different monument companies that people came in and picked out this stone that they saw, you know, outside and in their display and that they really liked. And then they said, well, you know, how many lots do you have? And well, we're going on 1 lot. Well, it doesn't fit on 1 lot. So, you know, again, don't know that you need a big headstone. And these, I don't mean to say like these are overly large headstones. They're just some of the bigger ones that you see that are pretty common and stuff like that. So, you know, it's up to you, but just something to think about. So most cemeteries will allow 1 casket and 1 urn, or 2 urns to go on 1 lot. So that's
Well, you had that one funeral here where she passed first, and she was cremated, and then he passed, and you put the urn in with the, in the casket.
Oh yeah, yeah, we get that request on occasions.
Yeah, it happened right upstairs.
Sure, yeah, it happens often.
I don't wanna spend eternity with one.
Need a little space, right?
He snores.
So when buying cemetery lots, if you're buying more than your 2, 1 for yourself, 1 for your spouse, let's say you're gonna buy a block of 6 or 8,
That's 8 and 3 here.
talk to the cemetery association about how their rules and regulations apply to who can be buried where, how they transition to your family after you're gone. It does become a spiteful moment between siblings and spouses when there's not enough space for everybody and somebody wants to add in their spouse next to them. And that might bump another sibling out. More so that was popular back in our younger days than it is now, because everybody's so transitional, we move a lot. But it does come up quite often. Buy 6 lots, they've got themselves and 4 kids, and then they
6
have
graves, that's a grave. A lot is 8.
8, all right, so 8.
So it's graves, but a lot is 8 graves.
Okay. So then something unfortunate happens, maybe a grandchild passes away and all of a sudden they're like, yeah, we're gonna put them here. And, you know, it can cause hard feelings, you know, for the children who are left going, well, I thought I was gonna be buried there with them, and now I can't. You know, so just things, but that is normally controlled by the cemetery association. It's not something that is like a deed recorded with registered deeds office.
And we see it a lot more often now because the older generation bought the lots, and now they're kind of getting filled or used up, and the younger people haven't been buying them because the families have had them, and now they don't know how many are there. So we're checking all the time to see if they have 1 or 6 or 4 or how many lots are left. So that's a common thing that we're doing now. Where 10 years ago, that generation of people knew how many lots were left, but the next generation, it's just something they don't have a handle on. You know, a lot of those were bought a long time ago for $8. Yeah, so all things to think about. Some other ideas, you know, maybe consider writing down facts for like your obituary. Maybe it's just a couple simple dates or a couple special relatives, friends, whatever it might be, but you can write down anything for that. And maybe it's even work history or anything like that. And another thing is, if you're in the service, if you have a discharge paperwork and stuff like that, find a copy of it, or at least have a copy that you can get to. And Ron and Sandy at the Veteran Service Office will pre-fill out if you think of those 12 by 24 plaques that are on the back of the headstones, they will pre-fill those out now if you want, and you can get it so it has all the things you want listed on it, your dates of birth, or, you know, however you want it filled out, because you can personalize those with your ranks and all the different things you can put on them, and they'll fill them out ahead of time and just hold that form, because then after you pass, they can submit them, and then that plaque can actually be made, but it can't be made till after, but they can put the document together ahead of time and have it waiting there just how you want it. So just an option, but it's kind of neat because, you know, not everybody knows every little bit that's available for those markers and stuff. So yeah. One of the last things that I have on my list is essentially to have what we call in this business the talk of a lifetime, and it's essentially what we've been talking about here a little bit is tell your family what you want for a funeral, tell your friends, neighbors, whoever you need to put on all those important paperwork and documents, and just have a plan and let people know what it is. And the church even has their form for that, kind of has all the things for your funeral service that you can fill out in there. And, you know, I know there's never seems like a good day to do it, but after we pre-plan with people, the first thing they say when they walk out the door, I'd say, Mandela, don't you think it's almost half the time? They say, oh, it feels so good just to have this done. I mean, we hear that, I don't mean to say all the time, but we do hear it quite often, that it's just something they've been thinking about, but just never do it. And I don't blame them. Nobody wants to really talk about that, but it's just what we hear. So I know we went through a lot of stuff. You guys have some questions and whatever it might be. What did we forget?
Just, you know, estate planning, as soon as you turn 18, you should have something in place. You know, yeah, you know, you might not own a lot, it may not make a lot of sense. You got children, grandchildren that are going into college, guess what? Their medical stuff is private now. They turn 18, that button clicks. So if they're away, your daughter's down in Iowa, have her do that just so that we have ability to make decisions, access information, same with the financial, so it's always good, you know, and transitions in life. Most people say, well, when's a good time to have a will done? Well, the last time to have a will done is the day before you go on that cruise and you want to name guardians for your kids. Because we're not going to get it done in one day. We're not going to sit down and have a conversation and, you know, life transitions. Not just because somebody moved and they have a new address now, but something significant happens. Change in employment is a good time to sit down and have a discussion. And when I mean change in employment, retirement. Do we need to change it every time there's a new grandchild born? Probably not. But if it's been 5 or 8 years since you last had your estate planning looked at, it's probably past time to have it looked at, because our forms we transition our forms probably every 3 or 4 years. There's a change made, it's probably every 5 to 8 years that we have something major come up, whether it's statutory, procedural, that we're modifying our forms, bringing them back up to date. But it never hurts to sit down and have a conversation. That's where it should start. Even if you're not sure whether you need something or need it updated, the best thing is to sit down and talk about it. It may be, yep, everything looks in order, we're good to go, you know. But there might be things that, you know, options that are now available that weren't when you had it done. Or child may have fallen out of your good graces or back into your life now, and you may want to change what you did before. So it's always just a conversation, that's where it starts.
Yeah. Anybody else have any questions? And we went through a bunch of stuff, and
So are you taking new customers?
Always.
Are you taking?
Always. Only one soul. You can meet with me multiple times.
very true.
His job is once.
Yeah, one and done.
That happened the other day with me. Lisa called me, it was November 4th, it's birthday, and she says, Ma, I was in Branson. And she says, Ma, what are you doing? Well, I had to tell her what I was doing. I was in the bathroom. And, she says, where are you? I said, I'm in Branson. I didn't tell her that I was going. It happened as a spur of the moment. I said, yeah, we were in that cruise thing, and Kathy said she had 4 seats empty. And, Sandy looked at me, and I looked at Sandy, and Sandy says, we only die once. But Lisa says, Ma, that's wrong. Sandy said, we only live once. Lisa says to me, Ma, that's wrong.
You only die once.
You only die once, but you live a lot.
Right.
But that's what Sandy said, we only live once, and we went to Branson.
Yeah. Well, good, thanks for all the questions and everything, so.
Thank